Mr. Ellis.
Very pleased, my lords. I appear with Mr. Bradley for Mr. Lars Windhorst, the appellant and judgment debtor. Mr. Vannegat appears for Mr. Levy, the respondent and judgment creditor. The judgment is a German court judgment dated the 10th of October 2003. It is over 18 years old. A copy appears in the supplementary bundle and will turn to it in due course. It is for the principal sum of €2 million. It was ordered upon a claim by Mr. Levy based on unjust enrichment arising out of a failed investment in 1999. It is a civil and commercial judgment under the Judgement Regulation. The judgment was proved in a German Insolvency Plan, which I shall refer to as a plan, opened on the 14th of January 2005. Mr. Levy voted on that plan, which is a main insolvency proceeding within Annex A. The plan is a composition. On the basis of a third-party contribution, it comprised all claims for more than would have been received at a bankruptcy at that time. It has not been set aside or revoked. The judgment was registered by Master Eastman in August 2020. The judge below refused appeal against registration and refused a stay of execution under the CPR. Those are the essential facts, my lords. I'm sure you had them in mind already. With your leave, my lords, I would develop my submissions under 4 headings. First, I have already stated the material facts, but I would wish to take you briefly to a couple of the underlying documents, most notably the plan itself. Secondly, and this is the heart of the submissions, an overview of 3 matters. First, the relevant concepts at work in the EU legislation and case law. Secondly, the relevant concepts at work in German law as explained in the evidence that is common ground. Thirdly, following from those 2, how the 3 grounds of appeal stack up. In other words, what concepts the grounds of appeal rely on and what we say are the essential errors in the judge's judgment. Under my 3rd heading, I'll then show you the legal materials, which I say bear out the propositions under my 2nd heading. Fourthly and finally, I'll return to the grounds of appeal and develop those briefly. As to the relevant facts, can I ask you to take up the supplementary bundle at page 64? This is the Insolvency Plan. And at page 66, one gets the narrative. We don't need to read all of it. It essentially explains the financial difficulties Mr. Windhorst and his companies were then facing. There was a corporate group bankruptcy, followed by a personal threat of bankruptcy. At page 68, you get the basic description of the composition, which is at the bottom of the page under paragraph 2.1. A solvent third party has agreed to make a contribution to pay creditors just under 2% of the value. One sees at page 70 why it's said that the composition is better than the alternative, because it's said in the middle of the page under the heading 3.3 quota as an allocation in case of a breakup. There would only be about €100,000 available at that time to his creditors, which over the page at page 71 would have paid just over 0.1%. So the composition was therefore substantially better. Now at this point it's implicit in what I've said. A composition is a form of discharge and payment. It pays less and would otherwise have no effect in law because it's a payment of less than the amount due, but because of the special architecture of insolvency, a composition of less than the full amount can discharge the debt.
I mean, I absolutely follow that as a matter of general English law. It seems to be a little bit more complicated than that in Germany.
The position, and I'll take you to the evidence at the heading I stated, but to get there ahead of time, you can see on page 71, there's a waiver of all claims. And I'll take you to the evidence of Mr. Lenhardt, which is common ground in the evidence of Miss Kuhlmann. And that evidence is that the plan is effective. Although it's been terminated, that means it's completed and its effect has not been revoked. What happens since that time is payments post-plan, which Mr. Levy says have revived the obligation. Now that's disputed. It's not put any higher than that. It's not said that it's agreed. It's accepted that it's disputed. There are two ways one looks at that. It's either a fresh claim, i.e. you accept the effect of the composition, you make some voluntary payments after the composition, a new obligation arises, or, as I think my Lord was alluding to, there's an argument that the plan no longer has its effect. That's a dispute as to the effect of the composition.
I followed that. But that isn't quite what I had in mind. My impression is that as a matter of German law, although you would expect the plan to be given effect, in some sense there is still some shadow obligation in the background, such that at least for unjust enrichment purposes, if the debt is discharged, exactly, you can't say that that was unjust enrichment because you were discharging the ghost debt.
That's right. It's called an imperfect obligation. That's because German law has a different theory of unjust enrichment, whereas we have an unjust factor-led approach. They have an absence of basis approach.
Yes.
So unless you have some legal theory of the obligation, the payment can spring back. So the discharge creates an imperfect obligation. In English law, we'd actually analyse it as a gift.
Yes.
If you made a payment post-IVA, that would be a gift to your former creditors. In German law, there's an imperfect obligation which you can pay if you want to.
Which I quite follow, but going back to where you started, when you say, well, I forget exactly how you put it, the waiver has effect and disposes of the obligation, that's not absolutely true as a matter of German law because there remains the imperfect obligation.
You're right, my lord. I had used the word discharge. I don't need to put my case higher than there being an imperfect obligation, because
yes,
imperfect obligation is one you can choose to pay or not to pay.
Yes.
And so I entirely accept that correction. The other part, and let's cut to it, is that German law also recognises a difference between the judgment and the claim in respect of the judgment. And the composition is in respect of the claim for which the judgment stands as it were proof. And the formal enforceability of the judgment is the quality of the judgment that it has as a matter of German procedural law. Now, under European law, that is the passport for that judgment to be internationalised. But what we say is the essential error in the judge's judgment on ground one, I've skipped a little bit ahead already,
yes, is
the judge's judgment at paragraphs, I'll give you the more accurate references in a moment, about paragraphs 52, 53, 55 and 58 as well, essentially rejects our case below on enforceability as a matter of European law, because she rightly said it's common ground that this judgment is formally enforceable. What her ladyship then did is rolled forward that conclusion into paragraph 66 of her judgment in refusing the stay. And that, we say, is the error. And that's why in this court we flipped our submissions 180 degrees to start with ground one, because the main point, and I'll say it's my main ground, is this is a judgment which in English court is the execution court, abiding by the European distinctions. It's bound to give effect to the Insolvency Regulation, and the Insolvency Regulation imports into this country the German law that makes an imperfect obligation of the debt in respect of which the judgment is still formally enforceable. But that's the quality of the judgment, being to say the judgment is final, binding, in a definite demand. As it were, that badge of enforceability is disconnected from the underlying right, which is the subject of the composition. And so, and we'll look at the cases, in particular PRISM, because PRISM accepts that there is this distinction between, if I use these terms, ex equatur and execution. The judgment has been imported into national law, but as the execution court, if you paid the judgment, you could go to the execution court and say, I've paid, and deliver proof. That would abide by the distinctions drawn in PRISM for the rapid importation of the judgment into other member states.
And I'm taking you a long way from where you intended, but as I understand it from PRISM, as I think you're saying, if you want to put forward a defence of payment, that's not an answer to recognition. It has to come in at the enforcement stage.
That's exactly right. And let me I'm very happy to be taken further into the heart of the issues.
No, I think you should go back to where you were going to be.
Thank you, my lord. Just give me one moment just to see what I should cut from the facts, because it's very clear to me that I don't need to go through much of the facts with you, my lords. I think in this case, can we start with the judge's judgment so I can hone in on that? This is in the core file. And the judge's reasons are expressed in essentially two parts. The first, as regards the appeal against registration.
Before you're going to get stuck into the reasons, can we hear a little more about the facts? In particular, as at the time you were before the judge, there was anticipated to be a hearing in Germany in September. Did that happen? And if so, what transpired?
My lord, I have an update for you. Thank you for taking me back to the facts. That hearing was adjourned. It's been adjourned to January. The reason we understand is a lack of judicial resources in Germany. So the position in Germany, my lord, remains as at the Court of Appeal judgment in Ham, which is that there's a conditional suspension which has not been complied with, that if you pay security, the formal enforceability of the judgment would be suspended. That has not been paid and the appeal has been relisted. That appeal is actually an action under section 767 of the German Procedural Code. I'll go through that when I go through the German materials, because that's material to the Bundesgerichtshof decision, which is common ground between the parties, that we say draws the distinction between procedural and substantive rights. If I might, I will come back to that at that time.
So when the hearing does take place in Germany in January, what will its scope be?
Its scope will be that by reason of the German Insolvency Plan, the German court should, as it were, take away the formal enforceability of the German judgment. It should declare it inadmissible, I think is the relief applied for. And when I go through the German materials, I'll show you.
Okay, so
it's easier to see it in one place, I think.
yes.
Because one of the issues that you have is none of the German judgments on the facts of this case tell you what enforceability means, because they're courts which know what it means. They assume it. And we can look at those judgments, but what they're actually talking about is international jurisdiction. That is the major part of their reasoning, which looks unusual to our eyes because they're reasoning by reference to the Civil Jurisdiction and Judgments Regulation. And briefly, and I don't think it's controversial, the Court of First Instance said it had no jurisdiction, so on the basis that there was no intention to enforce in Germany, and therefore under the Judgments Regulation, enforcement was in England. Now, that looks unusual to our eyes because these are intra-German judgments, so why is the Judgments Regulation at all in play? But that's all one gets. The meaning of enforceability comes from the BGH decision.
And just anticipating a moment more, when Ms. Vannegut makes her submissions, we will want to know whether it is still her client's position in Germany that the German court has no jurisdiction to determine these matters.
I can't answer that.
No, you obviously can't. I'm just
I mean,
laying down the marker because, well, anyway, yes.
I mean, it's a point we will be making. We don't want to do grandstand with the court. There is obviously a problem in this case if the German court isn't going to deal with it at all, and this court is the only court that will be dealing with it. That's one of the points that we say is systemic about why we must be right on ground one. There must be an answer to this in the executing court. Before I move on, let me just check my own list to see if there's anything on the facts I should draw attention to. For my part now, I'll move on to the judge's judgment, if I may, my The judge's judgment appears at tab 6 of the core bundle. The judge's reasons are expressed in essentially two parts. The first part concerning the appeal against registration, the material conclusions appear at paragraphs 55 to 58 and 60. At paragraph 55, the judge rightly calls that it's common ground that it's enforceable as a matter of German law. The common ground is only as to formal enforceability, which the judge rightly recalls at 56. At 58, her ladyship's conclusion is that Article 17 of the Insolvency Regulation does no more than say, do as in this court as would be done in Germany, essentially. So it's the same effect. So that's how she reads it. I note in passing the judge does not refer to Article 25 at all. I don't mean that unfairly, because at paragraph 37 of her judgment, she does cite it, and she also cites Mr. Gabriel Moss's cross-border insolvency. So I can't say it's an oversight, but it's certainly an omission from the material part of her reasoning. And having so held, you get the conclusion at 60 over the page, which is to say that the Insolvency Plan has not changed the formal enforceability of judgment.
I think you should assume that I'm going to be well behind my lords at most stages during this appeal. But to my way of understanding, enforceability is simply a label which doesn't carry any of the normal connotations that we would use in English law, because in English law, if you said that a judgment was enforceable, you would assume that you could execute in some way. But it's not. It's simply a status which enables it to be registered here. Have I understood that correctly?
Essentially, my lord, but let me just clarify. There are two sets of distinctions we're concerned with. One is under German law, what German courts mean by enforceability and substantive rights. It's implicit within the distinction they draw that they don't have a doctrine of merger. Whereas we destroy the underlying rights when we have the judgment, and you have the judgment which creates a substantive obligation which you could sue on if you had to. The German courts have a concept of formal enforceability, which is a quality that allows you to take the judgment from the trial court to the execution court, to which bailiffs are attached and so on, to execute your judgment. And the enforcement court looks to the formal enforceability of the judgment, which are its qualities such as final, it's binding, it's an indefinite amount, and so on. And then you see the idea of the substantive claim. When we get to the Bundesgerichtshof decision, you see that the court there says, if you want to challenge that, because the VGH decision is a very interesting case, because it's almost a mirror image of the present case. It's a UK bankruptcy going to Germany, and it says you must raise the bankruptcy discharge as a defence in a trial action. So there's a distinction between procedural and substantive rights. That's the first distinction, and it's at the level of German domestic law. You then have a parallel distinction at the European level. And the European level essentially says that if you have, under national law, a procedurally enforceable judgment, that is the passport for that judgment to be enforced around the member states by a registration regime. So whereas in days gone by, you'd have an ad hoc regime of exequatur, where you get one sovereign granting the rights of another member state judgment to come into their state and enforce, you now have a systemized set of rules in a regulation.
But when you say that's a passport to enforcement, you're almost reinforcing the ambiguity. It's really a passport to execution, isn't it?
That's why I was hoping to introduce...
It's a passport to registration and thence to execution.
And that's what I was going to say. At the European level, enforcement has this formal quality as well. And then the contrasting distinction at the European level is that the execution of the judgment is a matter of national law. And we'll come to this when we look at the Fortis case, because I say that case is pregnant with the answer in this case. Because in that case, shortly before the Insolvency Regulation came into effect, at a time when there was a patchwork of private international law rules in insolvency, you now have a mandatory scheme that says that this court must recognise the effects of a German insolvency judgment. And so the effect of the German insolvency judgment it is effective in the UK, and we as the executing court must attend to it. And going back to my Lord's question, paragraph 60 of the judge's judgment, the judge has held that the German Insolvency Plan doesn't affect the procedural quality of enforceability, and therefore the appeal against registration fails. Now that conclusion I'm going to challenge on grounds 2 and 3. The judge's conclusion in these paragraphs is not the subject of ground 1. Ground 1 attacks paragraph 66 over the page. I might just ask you to read that paragraph for my lords.
I must apologise for the fact that questions from the court are taking you out of your course. You had a very clear structure or roadmap for your submissions that you set out for us, which I commend. However, given the way that you've introduced this paragraph, can I ask you this question? And I'm sure you'll want to come back to this later. Would I be right in assuming that you would accept that some court has to determine the merit of the question of whether there's an affirmation of the debt under the 2003 judgment and a rescission of the waiver under the Insolvency Plan?
Yes.
Somebody's got to decide that.
I will tell you the answer to that.
And which court do you say must decide that question, and on what basis?
It will be a German court. I cannot give you chapter and verse on that, but my answer is that unless and until the German composition is set aside or declared invalid, it stands as a judgment, which I'll show you under the scheme of the regulation this court is bound to give effect to. Because judgments in insolvency are to be given effect to without formality. They benefit by cross-reference from the same set of protections as judgments under the Judgments Regulation. They are not to be reviewed as to their merits. So unless until that composition is set aside, which has not happened, or declared ineffective with respect to Mr. Levy, it is to be given effect to by this court. I think it is logical, given the nature of the dispute, that it would be determined ultimately in the German court. I don't know, and I can't give you a definitive answer, as to whether the German court is to analyse it as a fresh claim, because on the basis of voluntary payments made, you would set the premise of the composition, but the voluntary payments allow the imperfect obligation to spring into life as a perfect obligation.
Yeah, so this, and again, I don't want to take you out of your course, but a point that I will appreciate your assistance with in due course is, isn't it all rather unsatisfactory for this court to be preempting or being invited to preempt the decision of the German courts? And of course, life would be so much simpler if, chronologically speaking, one had the advantage of a final decision of the dispute in Germany. But we all have to face the fact that we don't have that advantage. But then the question is, well, what's the right course for this court?
And I say the right course is the stay of execution, because this court is a national court which controls execution under its discretion in the CPR. There's two ways to look at it. You either have a fully effective composition that hasn't been impeached, in which case you must stay. Alternatively, say there is a composition that's not been set aside, and there's a dispute, because the evidence puts it no higher than that. Because, of course, on Mr. Windhorst's side of the courtroom, he says the payments were made voluntarily and or in respect of other investment possibilities. So there's a dispute in that respect. And we say, given the composition has not by a judicial act been set aside in Germany, and given that the EU law is clear that that judgment can't be questioned as to its substance, this court would be permitting a collateral attack on the substance of that composition. And it's not inconsistent, and this is my law's point, with this court prejudge what would be going on in Germany. It's not prejudging that to say, I recognise in this court that there's a dispute that hasn't been decided with respect to the composition in Germany, but unless until that dispute is decided, I will stay execution here, as I'm bound to do. That, I think, is my answer to my law's question.
So the relief you would ultimately seek on this appeal is, leaving aside your grounds 1 and 2, is a stay pending the outcome of the German proceedings.
There's two logical forms of relief, I think. The most, as it were, purest, consistent with my submission is that unless and until the composition is set aside or declared ineffective with respect to Mr. Levy's debt, execution is stayed. Alternatively, and it's not as conceptually pure, is as my lord just said, just to stay execution pending the decision in Germany.
I mean, they may not really be different, I don't know.
I agree, they may not be different, but analytically I can see a difference, but in reality probably not. With your leave, my lord, if I may return to the judge's judgment. At paragraph 66, we say the essential error is the judge has rolled forward her conclusion on the basis of the formal enforceability, which would have you warranted dismissal of the registration appeal, and carried it forward without attending to the difference between formal enforceability and the substantive effect of the composition on the obligation. That's what we say is the essential error in paragraph 66. But before we leave the judge's judgment, I would draw attention to paragraphs 52 and 53, which are the judge's obiter dicta conclusion, in which she expressed disagreement with the decision of Mr. Justice Murray in the Percival case. And this is on the question of whether Articles 34 and 35 are exhaustive of the defences. Now, this is pertinent to ground 2 and ground 3. It's not relevant to ground 1. Just so you know where I'm going with this, we say two things. One, that the judge has made a mistake in paragraph 52. She's quoted Prism, which attributes the word exhaustive to the decision in Orams at 55. Orams does not say that. Arnold does not use the word exhaustive. That is a mistake. I'm not attributing fault to the judge in any way. It's simply that is not accurate and the cases haven't been analysed.
Sorry, so that's paragraph 55.
For paragraph 55 of Orams, paragraph 52 of the judge's judgment, the judge cites part of the decision in Prism.
Yes.
And she cites it at paragraph 33 of the decision in Prism for the proposition that the court in Orams held that Articles 34 and 35 are exhaustive of the grounds on registration. Now, if that's right, I didn't really get off the ground on ground 2.
But they're quoting from the Court of Justice in Prism.
That's right. But also quoting from their citing Orams at 55 for that proposition. So my point is, I'll take you through the judgments in order. Essentially, when one looks at all the CJE judgments...
Sorry, I'm a little puzzled. The quotation is accurate.
The quotation is accurate.
So you say the judge has made a mistake. You might be meaning that the Court of Justice has made a mistake, but the judge has accurately quoted what the Court of Justice said.
And my lord, I also said I attributed no fault to the judge because the point I meant is the one you just made. The Court of Justice has accumulated. We see this citation a couple of times in some of the judgments. As part of their reasoning, they say the court in Orams decided it was exhaustive. When you look at that part of the judgment in orange, it's actually concerned with public policy. It doesn't say the word exhaustive. It does say the word strictly, but the point I'll be taking you to is there's no case of the ECJ or CJEU that holds as its ratio that those articles are exhaustive. Indeed, all of them, except with respect to a debate about Article 38, as to enforceability, that there by definition must be points that one can take outside Articles 34 and 35. Now all of this is relevant to ground 2. In a way, it's a gateway. If I'm not right on that point on ground 2, I lose on ground 2. That's what I wish to show you on the judge's judgment, my lords. If I can now move on, that was my first heading completed. I was going to move on to my second heading. We've actually discussed much of it already, but if I can set it out briefly and perhaps more systematically.
I'm sure that would be helpful. So don't let us hurry you into jumping forward in your submissions when that isn't really going to work.
And I do hope you don't mind me drinking
No.
directly. I'll take this in stages, dealing first with the Judgments Regulation, then the Insolvency Regulation, and then German law. I'll obviously interweave parts of grounds 1, 2 and 3. Starting with the Judgments Regulation, and going back to my Lord Justice Stuart-Smith's question, the Judgment Regulation distinguishes between the registration of a judgment given in one member state in another member state, and the execution of that registered judgment in that state. The rules for the registration of a judgment are a form of exequatur. They internationalise the judgment of a member state court within the EU. It is then for the courts of the other member states to control execution in accordance with the national laws of those states. The distinction between exequatur and execution, if I might use those terms, is made, firstly, to facilitate the rapid transmission of a judgment given in one state into others, to facilitate EU-wide enforcement of that judgment, and thus to support the creation of a single market. Secondly, it is done in recognition of the differing national laws that must ultimately control execution in a given state, including by means of legal compulsion if required. In order to fall within the regime exequatur under the Judgments Regulation, a judgment given in one member state must satisfy certain conditions. The court is required to register a judgment given in a member state if and only if those conditions are satisfied. For instance, it must be a civil and commercial judgment, and it must be enforceable according to the national law of the state of origin. This condition is one that has been labelled a perimeter question. That's what we see the editors Dyson Morris use, Professor Briggs, Professor Fawcett. There are other such qualifications within the Judgments Regulation, none of which are listed amongst the closed list of defences in Articles 34 and 35 that might be considered in an appeal against registration. The list of defences is necessarily limited in order to facilitate the rapid transmission of defences, the rapid transmission of a judgment given in one state into another. In fact, it's so important it's said twice in the Judgments Regulation that you cannot review a judgment as to its substance, by which they mean its merits. That narrow list of defences, plainly, in our submission, does not override a perimeter question. If the judgment, for instance, were a public law judgment, it would not even be within the Judgments Regulation, and thus the provisions that regulate or purport to limit the defences would not themselves apply. Ground 1 is an appeal against the judge's refusal to stay execution in the exercise of her power to do so under the CPR. Ground 1 is not concerned with the appeal against registration. Ground 1 relies on the distinction between exequatur and execution. Execution is controlled by the CPR, and we say the stay of execution must occur because the judgment has been proved in the plan, and the plan is an effective composition which the court must recognise under the Insolvency Regulation. The judge, for her part, appeared to accept the premise of this argument, being the difference between exequatur and execution, but rejected its conclusions for the two reasons we've seen. Essentially, her view is that Article 17 directed her to do as was done in Germany, and she regarded formal enforceability in Germany as an end to the question in this court, and we say that elided the distinction between substantive rights and procedural rights. Moving on to the Insolvency Regulation.
Just, are you going to take us through the key provisions of the Judgment Regulation?
Under my third heading, absolutely. I just wanted to give you the propositions and then make good those propositions by reference to the legislation first,
Yes.
and then the case law. I thought if I did it in a more jumbled up way, I would be slower,
Yes.
and I would probably aggravate you.
lose some members of the court.
Essentially, that was my fear.
All members of the court. Yes.
The Insolvency Regulation recognises that national laws on insolvency are divergent, and that absent
Can
harmonisation...
you just slow down? I'm trying to keep up.
I apologise.
It recognises what?
National laws on insolvency are divergent,
Yep.
and that absent harmonisation, the aim of achieving a single market is facilitated by EU-wide effectiveness of insolvency proceedings, which are an important part of a functioning market, either as a means of collective execution, for example, liquidation or bankruptcy, or as a means of rehabilitation, such as a corporate restructuring or a debtor's composition with their creditors, as we have here. To that end, the EU Insolvency Regulation uses the concept of combing, or centre of main interest, to identify a main proceeding that has EU-wide effect. This list of proceedings is controlled by Annex A to the Insolvency Regulation. The Insolvency Plan is a proceeding within Annex A. It is entitled to European-wide automatic recognition of its opening and effects. Article 25 is express in saying that automatic effect is to be given to the terms of a composition. I've already noted that the judge didn't refer to Article 25 in the operative part of her judgment. To give you the references, my lords, she did, however, correctly cite Article 25 in its commentary, paragraphs 37 to 39 of her judgment. Moving on to the German law, which I'll come to as to the evidence in detail in a moment. None of the German procedural judgments in this case denies effect to the German Insolvency Plan. All are concerned with the German Code of Civil Procedure, referred to by the acronym ZPO, and it is plain, as I will show you by reference to the evidence and the underlying materials, which are not in dispute, that enforceability in the sense used in the German procedural judgments is a formal sense of enforceability.
Is a what?
A formal sense of enforceability. That is, those judgments are concerned with the quality a judgment must have, such as being final and binding, in order to qualify as one in respect of which execution is permitted, subject to the control of the executing court. German law, on the evidence, draws a clear distinction between formal enforceability of the judgment as a matter of German procedural law and the substantive obligation in respect of that judgment. The Insolvency Plan is a defence with respect to the substantive obligation, because the composition affects a release of the perfect obligation and substitutes an imperfect obligation that cannot be pursued by the creditor. I would readily accept that the German Insolvency Plan is not a defence to the formal enforceability of a judgment under the German Civil Procedural Code, but that is nothing to the point. It is a defence to the substantive obligation. In other words, the composition that must be given effect to is in respect of the in personam obligation to pay money. the composition is not in respect of the formal enforceability of a judgment. Indeed, any suggestion that there could be a quote composition in respect of the quality of a judgment to be final and binding is an odd suggestion. It would hardly make any sense, and it's never been part of our case. And we say, as I mentioned already, that it's this distinction between procedural and substantive rights that the judge failed to attend to in paragraph 66. Those are the essential points on ground 1. On the basis of the concepts I've introduced, may I just tell you briefly about grounds 2 and 3? Grounds 2 and 3 aim at the same point, but they are analytically different routes to it. They have a common starting point. The common starting point is the proposition that Articles 34 and Article 35 are not exhaustive of the defences that a judgment debtor might take in respect of registration. If I'm wrong on that, I think I'm probably wrong on both grounds 2 and 3. The difference between grounds 2 and grounds 3 is that ground 2 identifies a conflict with the result required under the Insolvency Regulation and says that that must be a permitted challenge that a debtor can take. If the court's not with me on that ground, what I seek to do, by reference to the dicta of Advocate General Cocott in prison, is to extend the meaning of enforceability in Article 38 to an EU concept of enforceability that includes, it must include enforceability under national law, but it has a negative aspect as well, which is if there is a judicial act that has effect throughout the EU as a matter of community law, that is sufficient to negate enforceability. Now that's the view that Advocate General Cocott said did not have to be decided in prison expressly, and the court said nothing about it either. But the Advocate General did express a view, as it were, obiter from our point of view, to say that much could be said for that view. The reason for it is that unlike the contractual ad hoc settlement in prison, which could be difficult to police and check at the enforcement stage and would therefore slow up the intended rapid transmission of judgments, the Advocate General accepted that a judicial act recognised under other EU legislation didn't have the same problem. And that's the argument essentially on ground 3. If we can then move to the legal materials, and this is the main part of my submissions and will be in the authorities bundle for some time. If we can start with the legislation, and we'll start with the Judgments Regulation, which is at tab 2 of the bundle on page 21. I'll be guided by my laws as to how slow or how fast I should move, but I was planning to start with the recitals and move to the
I think I would take us through it.
If I can then ask you to read recitals 2 and 7 on the first page. I'm taking you to these to bear out the propositions, so sometimes they will be self-evident, and I'll just move on once you've read it. And then moving on from recitals 2 and 7 to recitals 16 through to 18. And that's a broad description of the procedure for registration and appeal. Moving then to the operative terms, these will be more or less familiar. Article 1 draws the distinction between civil and commercial matters in the first subparagraph, and then the excluded matters, bankruptcy, status, social security, arbitration. We can skip all of the jurisdictional rules and move to page 30, Article 32, which defines judgment for the purpose of recognition and enforcement. Articles 34 and 35.
Sorry, I wasn't keeping up to date. So the you said page 30. Oh, yes, that's the Article 32.
Article 32.
Yes.
And then, having defined judgment, it then goes on to have two subheadings. The first is recognition, and then enforcement over the page. This is chapter 3. Can I invite you to read articles 34 and 35? And I would suggest reading those with Article 45 over the page. In particular, you'll see the word only in Article 45.1, which is really at the heart of the issues on grounds, rather it's a gateway issue on grounds 2 and 3. And so then, moving on to Article 38, and I'll begin to develop the submission. You see in Article 38 the conditions for enforcement, one of which is and enforceable in that state. Pausing there, if Articles 34, 35 and 45 were to be read literally, one could not dispute enforceability under Article 38.1, because Article 38.1 is not within Articles 34 to 35. And this is a point made by the academic writers, all of whom speak with one voice, that one cannot read Article 45 too literally.
So I'm clear. So the point you're making is Article 38 simply says that it is to be enforced once it's been declared to be enforceable.
A judgment given in a member state and enforceable in that state shall be enforceable in another member state. So a precondition to enforcement in a state such as ours is the enforceability of the judgment under the domestic law of Germany.
Yes.
If one wished to dispute the enforceability of the judgment, and we have cases in the jurisdiction, there are 3 of them, which dispute the enforceability, some of whom call expert evidence in order to do it. You cannot take that point if Article 45 is to be read literally and to confine disputes to the stated matters in 34 and 35.
And when you say enforceability, you mean enforceability as moving to execution?
No. At this stage, enforcement means procedural enforceability, I think, in Article 38.
Are you going to take us to where it says, you gave us a list of fundamental criteria, final judgment, binding, blah, blah, blah. Where do we see those in the article?
They're not spelt out.
They're not spelt out.
I'll take you through the opinions of the Advocate Generals in the court, and they explain that enforceability is not defined in the regulation.
Is your point simply this, that under Article 38, it must be open, for example, to someone to say, well, this wasn't a judgment given in a member state, although
Yes.
that doesn't appear in 34 and 35?
Exactly.
I mean, it may be inconceivable.
It is that quality of point.
And on the same level, it's got to be enforceable, therefore you must be able to say it's not enforceable.
Or you must be able to say that it's not a civil and commercial judgment because it's in fact a public judgment, or it's an award in arbitration. These points are not listed within the closed set.
I'm getting myself confused. You've got the recognition stage and the enforcement stage.
Yes.
At the recognition stage, on your case, can you take perimeter issues?
There is. I've unfortunately, because I've jumped around, I should show you the rest of the articles. The structure of the regulation uses the headings recognition and enforcement. And my lord's question logically assumes that enforcement presupposes recognition. But if we let us read articles 39 onwards,
Yep.
because the way it works is that recognition is wholly procedural.
Yes.
And what you achieve by enforceability at Article 41 paired with Article 45 is a declaration of enforceability. That is the registration of the judgment.
That's what you mean.
So enforceability in this sense isn't execution.
Yep.
And so I might just ask you to read for yourselves, my lord, Articles 38 through to Article 45.
That probably is wise.
My lords, it may also assist in this part of your reading to read Articles 53 to 55 over the page as well, which deal with common provisions as to procedure, because that will give you the overview. And if I might crystallise the issue in this way, on the facts of this case, the end point of the quote enforcement procedure under these articles is Master Eastman's order. It is not execution as in a charging order, third-party debt order, and so on. It is concerned with the recognition and enforcement of a peace, the import of the European judgment into UK. And the point I was making, which I think my Lord Justice Stuart-Smith made for me and shortly, is that there are these perimeter questions lurking out there. Is it from a member state? Is it civil and commercial? Is it enforceable? None of which are within Articles 34 and 35. And the commentators who deal with this problem, as we'll see, have suggested various ways of dealing with it. The most elegant of which is that recognition enforcement presupposes recognition, and therefore there is license within the terms of the regulation to take these sort of points. The other of which, as I've outlined, is that when one has a perimeter question, it's a question as to the material scope of the regulation. So if one's taking a perimeter question, any provisions within the regulation that say one can't take any other questions but these can't logically apply to a perimeter question. That doesn't make any sense. And the adaptation in this case, and just to run ahead of myself a little, Ground 2 highlights, and we'll come to it in a moment, that the regulation carves out from its material scope the effect of other legislation. There's a provision to carve out conventions and treaties. There's a provision to carve out conflicts with other aspects of community law. And that's essentially the point I make on ground 2. When we look to Article 67, we'll see that this regulation doesn't conflict with other parts of community law. I say in this case there would be a conflict, and therefore you can take the point at the enforcement stage. That's my case on ground 2. Ground 3, as I've introduced, really focuses on the words of Article 38.1 and looks to develop those so that enforceable in that state has a community law aspect as well, and that's relying on the Advocate General's opinion in prison, which we'll come to in due course.
When you use the word enforceable in the context of Article 38, in the context of enforceable in that state, are you using it to mean executable? Or are you still using it simply as being a judgment which satisfies the perimeter questions?
I'm adapting the meanings. It's an extended meaning. In ground 3, I am loading in a substantive element into the meaning of enforceable. I accept it's an adaptation. Ground 3 is analytically distinct from the other grounds I've introduced, my lord. So the short answer is I'm using enforceable in a different sense in relation to ground 3. I acknowledge immediately 2 things. That may be a reason why I'm wrong on ground 3. The other thing I acknowledge is it says enforceable in that state, which you might read as a delegation to national procedural law and importing no other requirement. That's another point taken against me on ground 3. I take it against myself, recognising that the Advocate General saw that there was much attraction to it. And that's what I rely on in this court. But before I move on to the Insolvency Regulation, and can I just deal with a few other points on this regulation? On Article 45, the important words are the word only. That's the most important word in Article 45.1 for present purposes. That is, read literally, the argument against him as a gateway question on ground 2. I won't repeat the main part of the argument, but can I just draw attention to part of my learned friend's argument, which I say is important. What my learned friend says at paragraph 34 of her written submissions is that disputes about enforceability are permissible. So you can take an Article 38 dispute, notwithstanding Articles 34, 35 and 45. However, the submission is made that an Article 38 dispute is confined to manifest procedural defects. That's the point that's made. And I would submit that that concession is fatal to the case on the exclusivity or the exhaustivity of 34 and 35. It's fatal because it accepts that there are matters outside those articles. What it seeks to do is then to constrain those matters to manifest formal defects. But that point is orthogonal to the issue at hand. The issue at hand is Article 45 plus 34 and 35 exhaustive? As soon as one accepts that there's any sort of exception to it, that concession is damaging. I would suggest fatal. And so the attempt to constrain it to formal procedural defects is damaging. I would add, before moving on, that if one looks at the personal case, each side had expert evidence as to what Italian law is. So how one analytically confines it to a formal procedural defect or a manifest procedural defect, I do not know. Finally, on the Judgments Regulation, can I invite you to read Articles 67 and 721?
67 and
71. These are pages 34 and 36. So Article 67 is dealing with other community instruments. Article 71 is dealing with treaties and conventions. So Article 71, if you've got a treaty on arbitration, New York Convention stuff, Judgment's regulation should not prejudice what goes on under the New York Convention. Article 67, this regulation should not prejudice other community instruments. And as a matter of jurisprudential history, we'll come to it when we look at the Fortis case, it was always meant to be the case that bankruptcy should have been included in the Judgments regulation. That was the original ambition, but it could not be achieved. And the Advocate General will look at the passages, explains that they got split up because the complexity of bankruptcy meant the convention couldn't be achieved by negotiation in time.
You're about to leave the Judgments regulation.
Okay.
Can I just
Yes.
Also note Article 22. So Article 22 says that the following courts shall have exclusive jurisdiction regardless of domicile, and then 5 is in proceedings concerned with the enforcement of judgments, the court of the member state in which the judgment has been or is to be enforced. So if you're dealing with execution, on the face of it, the court where you're seeking execution has exclusive jurisdiction.
Yes.
Just taking out of your course for a moment, Prism says, as I understand it, that if there's a defence of payment, that doesn't come in at the enforceability stage, it comes in at the execution stage.
Yes.
So if you're concerned with the defence of payment, does the court where execution is sought have exclusive jurisdiction?
I would think so, yes. Yes. I think the reason the execution court has exclusive jurisdiction is because it's controlling the execution within its territory. Now, whether that judgment on execution can then be exported to other member states, I'm not so sure. I think
So just pausing one moment. So I get a judgment against you in Germany for so much. I then get it registered in this country and seek to execute on it.
Yes.
But you say under German law the debt has been discharged.
Yes.
That has to be determined, you say, in the English court.
Can we take the example of payment first and then move on to the other discharge by judgment? So in the issue of payment, if you sought a third-party debt order or a charging order against my home, I would be able to say, I've paid you, and I'd be able to show the master the receipt, and he would refuse execution. And he has sole jurisdiction to refuse execution. No other court in the EU can do that.
And if there's a dispute as to whether the particular form of alleged discharge affects a payment under German law, is that still an issue for the executing court?
Well, moving on to that example.
Yes.
So I come along and say, you shouldn't make a charging order over my home because I've done a bankruptcy plan in Germany, and the judgment creditor also appears and say, well, look, I dispute the effect of that plan, and you, the master, have to deal with it. I think the master, all he's doing is refusing execution, and he can refuse execution without deciding the effect of the German Insolvency Plan. Because what he's seized of is in proceedings concerned with the enforcement, so the charging order application, he has sole conduct of a charging order application. He doesn't need to decide the merits as to the substance of German insolvency judgment, which brackets, as we'll see in a moment, he's not allowed to do in order to reach a conclusion as to execution.
Can I just, I follow that where you've got the insolvency regulation in play, life may be more complicated. But suppose the insolvency regulation isn't in play.
Yes.
There's a dispute of some kind.
Well, it's
as
in
to
play in
whether,
the time capsule of this case, but otherwise it's not.
let's assume that the debtor says, I provided this in satisfaction of the judgment.
Yes.
No question of insolvency, it's just a question of whether the this is good enough to discharge the judgment under German law. Who decides that?
It would be the National Court, because, we'll go through the case law, they control...
The National Executing Court.
The Executing Court would control execution.
Master Eastman.
Yes. And so you could have a situation that was this. You get your German judgment, you come to the UK, the debtor proves payment in the UK, execution is refused in the UK, and then the judgment creditor takes the same judgment and goes to France. And the French court may have to have the same debate all over again. I mean, this is one of the reasons why in this case I'm actually pursuing grounds 2 and ground 3, because where one has a community composition, it seems unsatisfactory that one has this game of whack-a-mole, that you have to go around and squashing down the formally enforceable but paid judgment. Now that's fine if the defence is payment, because PRISM tells us that has to be the right answer, because payment is a complex question. Sometimes it can require bank statements to be produced, and the court doesn't want any of that to clutter up the rapid transmission of a judgment. That's all dealt with at the execution stage, and that is dealt with in each national court that has the question of execution before it.
And just pursuing it a moment longer, if the Article 767 type question were thought to be an aspect of execution, then Mr. Levy could indeed say that the German court had no jurisdiction. Or not.
Article 67.
767, sorry. In terms of the
I
German proceedings, whereas I understand it has in the past at least been suggested by Mr. Levy that the German court has no jurisdiction.
I think I followed. My law's question
That might make sense if what was really at issue here was execution, because then it's a matter on the face of it for the executing court.
Yes. I think this must mean execution.
But then what happens if the German court in January or February or March or whenever finally it deals with this, rules that the effect of whatever has been put in front of it is that the debt, the judgment debt under the original judgment has been discharged? What should the national, and then Mr. Levy goes to France, Luxembourg, England, wherever he wishes to go, what is the answer to him? Is it the answer to him that, or is his answer that the 767 proceedings have no effect whatsoever? Or is it that they, at the other end of the spectrum, they're decisive, or what?
Well, let's take the two possible answers on the 767. One is the judgment is formally enforceable, but the plan means I can now take away that formal enforceability. The other of which is I reject Mr. Windhorst's submissions and the imperfect obligation has revived by reason of the payments and becomes a perfect obligation. Those are the two extremes. Now, the German court that's dealing with this is the German trial court. We'll look at the labels. It's not the enforcement court. And so that would be a civil and commercial judgment. So if you had a civil and commercial judgment that said the imperfect obligation has now become again a perfect obligation, then that would affirm an obligation that could be enforced. And presumably the German court would either say, here's another judgment which allows you to sue.
So then Mr. Levy would come along and say, you don't need to worry about the 2003 judgment. Look, I've got my new judgment,
yes,
which falls within the judgments regulation.
Well, he either says it's a new judgment, or the German court might just say the perfect obligation has revived and this original judgment is still good enough. I don't know what options are available, but yes, the answer is if the judgment court rejected Mr. Windhorst's case that the obligation remained an imperfect obligation, as if he lost in Germany, the effect of that loss would be felt because it would be transmitted into this court under the judgments regulation, because all this is governed by the transitional regime. Conversely, if you won and the German court said no, the composition stands, this remains an imperfect obligation, then the German court has effectively declared what this court is required to treat as the position, because this court is only cognizant of a dispute in Germany. That dispute will have been resolved in Mr. Windhorst's favour, and therefore execution should be permanently stayed.
So really, this is a bit subtle for me, I think. I think what you're saying is, if the German court does nothing, then questions of execution are purely for the executing court, last resort law of this court, or whatever it may be. But if the German court is persuaded to declare in another civil or commercial judgment what the impact of the insolvency plan and the original judgment and any payments that have subsequently been made, then that would, at least in effect, take back from the executing court, namely England, to the German court, determination of what the correct answer is.
Yes, in terms of a satisfactory systemic answer, the English court is controlling execution within its territory, so charging orders, third-party debt orders and the like. If I prevailed today and there were to be a stay, we've already discussed the terms of that stay, and the German court were to decide one of the two outcomes I've outlined, those outcomes, whichever way, will be fed back into this court, and presumably, if Mr. Levy prevailed in Germany, he would then apply to lift the stay.
Just talking around just a moment longer, a third conceivable outcome, if I've understood what has so far been put to the German courts, is that the German courts say, well, we can't answer the question. It's not a matter for us.
Yeah, no, that's right.
Yeah.
In which case the answer is you still have a composition that still stands and hasn't been set aside. And in this court, one has to give effect to it. The fact that the German court has declined jurisdiction on the application before it means ceteris paribus.
Is that right? If the German court says it's got no jurisdiction, why can't this court determine the question, the English court?
I've not thought
Some
about
court's
that.
got to decide it.
My lord, I can't see a reason why not if the German court has declined jurisdiction. I don't want to hang my hat on it until I've thought about it. Can I come back to you?
Just putting it into the mix when you do think about it. You haven't got to the Insolvency Regulation yet, but in Article 4 of the Insolvency Regulation says that deals with the applicable law. And the applicable law in relation to creditors' rights after the closure of insolvency proceedings and other things would be German law.
Yes.
So if it were a matter for this court to grapple with the question in respect of which the German courts have declined jurisdiction, presumably we would be doing so by seeking to apply German law.
Yes. If this court felt that in dealing with execution, it had to take upon itself the burden, if that were permitted, because the German court were not to do so, which I'll come back to, my lord, probably after lunch, after I've had a little time to think about it, that would be the right law to apply. But my basic submission is that the execution court sees an application to stay execution, which is the only question for the execution court, does not need to enter into that debate in order to affirm a stay. If I might, my lords, move on to the Insolvency Regulation. This is at tab 1 of the authorities manual.
Could you just hold on 1 second? So that, but this is correct. If the German court determines the present position under German law, that would feed to the English court, I think was the phrase you used. If the German court declines jurisdiction, then it would be for Great Britain or the United Kingdom as executing court to make up its mind on the basis of German law.
I've not answered that question yet.
Okay.
That was
I'll
a
put
question
a
my
question mark.
Lord Justice Arnold.
I'll put a question mark in.
I will give you an answer if I can.
Thank you.
Yeah. On the Insolvency Regulation, can I ask you to read recitals 6 through to 8, please? Then can I invite you to read the first sentence of both recitals 11 and 12? And then over the page, recitals 22 and 23 in full, please. So thinking about a case that's common in these courts, well, it was common until Brexit, why we had so many European debtors bankrupting themselves here is because the discharge of bankruptcy is effective throughout the whole of Europe. This case goes the other way. You've got a German insolvency plan that's effective throughout the whole of Europe. As to the operative provisions, can we turn first to Article 1.1? So this is the type of proceedings it's concerned with. We can turn up Annex A very briefly. This is at page 16. And one can see under, I always lose my place on
Is
this.
that under the Deutschland heading?
It's on the left-hand column, and it's the fourth bullet point. As to COMI in international jurisdiction, that's on page 7, Article 3.1. It's a main proceeding. Article 4 is the applicable law, which my Lord Justice Newey was referring. Can I invite you to read the first paragraph of that, and then subparagraphs G to K. In particular, J and K. It's German law that determines the effects of the composition and the creditor's rights after closure of the insolvency proceedings. In terms of recognition of those effects, I'd ask you to read Articles 16, 17, and 25. to just put some flesh on the bones of those articles, if you take an English proceeding to make it familiar, if you have an English administration or winding up, as soon as it's opened, the effect of the rare condition in the moratorium is transmitted throughout Europe. That's what Article 17 does on the opening. If the liquidator or administrator then proposes a CVA or a scheme of arrangement, that would be a composition. Certainly a CVA would be a composition. I think a scheme of arrangement has always been more difficult. That would be a composition effective throughout the EU under Article 25. It also says that such judgment shall be enforced in accordance with the Judgments Regulation, taking the benefits of Articles 31 to 51. Those articles include that you cannot review it as to its substance. Just a point of distinction here, and there are many kinds of judgment that can emanate from an insolvency proceeding. A composition is obviously one of them. A composition rarely needs to be enforced by an action, because one just takes the effect of its recognition without further formalities as a defence. And that's essentially what I'm seeking to do here in support of the stay under the CPR. There are of course other such judgments, such as preference actions, TUVs, which turn into money judgments, which have to be enforced. And that's why an enforcement regime is tacked on expressly.
Is the numbering of the articles the same when we come to the regulation? Because this, of course, is referring to the convention.
Yes, it hasn't been updated, but the numbering is the same.
It isn't actually the same, is it? Under the Judgments Regulation, I made a note, rightly or wrongly. According to me, the relevant articles are now 38 to 58, except 45.2.
I'm grateful for the correction. I'll check, but I think that's probably
so you'd
right.
be, well, you wouldn't be adding 7 in every case.
It would still cover, I think, Article 45.2, which is you can't review it as to the substance. We'll just do a quick cross-reference to that.
When I was making a note, I said that 34.2 had become 45.2, but I wouldn't like to say that I was necessarily right.
We'll check that, because it occurred to me, but I just haven't made a note of it in my script. Mr. Fradley behind me will check that, because it's a relatively important point. I think it's right. And I was going to develop it briefly, because in paragraphs 47 to 49 of my learned friend's skeleton argument, the evidence is correctly summarised that there's a dispute as to the effect of the voluntary payments and their status with respect to the composition. That is a dispute and no more, it's not put higher than that. And the submission is made that this makes this case alike prison, and it's part of the answer to my case on ground 3, that because there's a dispute, the case is therefore prison-like. My answer to that is, this court cannot review the composition as to its effect. That's not permitted, unless and until it's set aside. It's a judgment that cannot be reviewed as to its substance. Yes, it's not a familiar form of judgment in terms of an in persona money obligation, but the composition has the status of a judgment, and it has it for the purpose of allowing a debtor's rehabilitative proceeding to have EU-wide effect. So long as it stands as a matter of German law, which is common ground, one can't collaterally attack it. That's all I wanted to show you on the Insolvency Regulation manuals. I was now going to move on. And just so you know, I'm running roughly to time. I think I've got about 30 minutes left, maybe a little more, but I'm now going to run through the cases, and what I hope is...
Well, you told us you were going to take us to German law next.
I was going to take to the legal materials, which was my third heading. I was going to do those in order of legislation, EU case law, and German law.
Right, fine. I misunderstood. Thank you very much.
On the EU case law, can we start with the case of Brasserie de Pêcheur at tab 4 of the bundle? I hope you'll excuse my mispronunciation of EWHC. I will take the most pronounceable bit of it and try and say that. The issue in this case was whether a third party to the judgment debtor and judgment creditor could challenge the registration of a judgment under the then Brussels Convention. The answer given by the European Court of Justice was no. It said that any such rights had to be pursued at the level of national law if the national law allowed a third party to intervene. The decision is relevant to the present case because it makes the distinction between enforcement registration and execution at the national level. Having briefly summarised the facts, can I ask you to read paragraphs 16 to 19 of the judgment at page 60? Moving on, my lords.
So just to be clear, the point you're really getting out of it is paragraph 18, the distinction between enforcement and execution.
Yes, and I'm going to show you the line of cases in chronological order. That line is drawn brightly all the way through the cases, of which PRISM is the latest, most developed jurisprudence.
Yeah.
The next case is Fortis at tab 5 of the manual. This is the case I said, I think, in my opening, that it was pregnant with the answer in this case. Because it's a pre-insolvency regulation case, one of the last cases before the insolvency regulation came into force. The issue in this case is a French judgment debtor obtained a discharge under a French insolvency plan. He then moved to Luxembourg, which did not recognise the effect of the French insolvency plan. And that was because Luxembourg private international law, as it then was, had a universalist theory of insolvency proceedings, rather like universal succession, but it wasn't totally symmetrical. If the national law, in that case France, confined its insolvency proceeding to the territory, Luxembourg law would not give effect to it. So the French debtor, having become a judgment debtor in France and having dealt with it in France according to a territorial insolvency proceeding, he then moved to Luxembourg and he was pursued by the creditor. And the issue is whether he could challenge enforcement, and he lost. And this was at a time when there wasn't an insolvency regulation. And we'll see it in the judgment and the AG's opinion in a moment, but essentially he had lost his shield. That's the term they use. And the Advocate General recites the history of the insolvency regulation, and what one can see implicit within the reasoning, that the answer would be different now. I'll come to what my learned friend says about it, but I want to show the EU framework. So can I ask you to read the head note on pages 62 to 63, which sets out essentially what I've just said. If we can pick up the reasoning, first with the Advocate General's opinion, page 71, I'd invite you to read paragraphs 12 to 14. The Advocate General's opinion was followed in this case, and it has a useful exposition of the jurisprudence and its background.
So, sorry, which paragraphs did you want
Paragraphs 12 to 14,
Yeah.
beginning on page 71.
Yeah.
The first line is, the concepts of recognition and enforcement are not expressly defined in the Convention, which is a question, my Lord, which Stuart-Smith asked me earlier.
Yeah.
Then I invite you to read paragraph 15. You'll note at the end of that paragraph a particularly interesting debate about discharge and its availability in offence. Now, the law's moved on. Advocate Cocott is the last word on that.
Yeah.
On page 77, my lords.
So just pausing there,
Yes.
picking up the point you made, we see the sentence suggesting that the debtor can raise objections because of, for example, evidence that the debt has been discharged, and there's a reference to the Genar report. But that, as you say, has been overtaken by PRISM.
Exactly. And so that's why on ground 3 I focus on what the Advocate General says about a discharge by judicial act effected throughout. That's the unresolved question in PRISM that I'm putting before my lords today. I entirely accept that the question of payment that the Advocate General raised in this case, in PRISM it was an ad hoc contractual settlement. That's been and gone. I'm not relying on this for that purpose.
Yep.
On page 77, I was going to ask you to read, you've got paragraph 21, it's a long paragraph. I was going to ask you to pick it up halfway down the page, the words, as we know, which sets out the history of how the Insolvency Regulation and the Brussels Regulation took their separate course. If you turn over the page and just read to the end of that paragraph. And finally, on the Advocate General's opinion, paragraphs 22 and 23 explain the absence of the Convention. It actually quotes the embryonic Article 25, where the ellipsis is actually up in the bits where he's dotted out the words composition. But he then goes on to explain the private international position absent that harmonised regulation. And it's the patchwork of national laws, which in this case means that Luxembourg doesn't recognise the French discharge. And without reading the rest of this opinion together, can I just give you the most pithy expression of its conclusion on page 80? It's halfway down the page, beginning, it's the sentence in the paragraph 25 beginning, on the other hand, by taking up paid employment in another contracting state, he had lost his shield. That's the most succinct expression of the conclusion based on the foregoing reasoning. And this was followed by the court, and the pertinent paragraphs of the judgment of the court are paragraphs 24 to 33. On page 86 and following.
Sorry, which paragraphs again?
24 to 33
Yeah.
on page 86 and following.
Yep.
With 24, we see the distinction between formal enforceable terms contrasted with payment as a substantive discharge of the obligation. And then paragraph 28 regulates the formal procedure for registration, does not deal with execution, which continues to be governed by the domestic law of the court in which execution is sought, here the CPR. And my lords, I'd ask you to note at paragraphs 29 and 33 the words solely to the enforceability in formal terms. Those are obviously points against me on ground 3. They are points that are actually supportive on ground 1.
So just pausing for a moment. It's contemplated that the Luxembourg court can take account of the French rules if its rules of private international law allow that.
Yes, which they didn't in that case.
Which they didn't. But supposing they had, it would have been open to the Luxembourg court to take account of the French procedure.
I would go further. When you say take account, there's a question of is one taking into account as a discretionary matter, or is it an obligation? Now,
Which I suppose would turn on Luxembourg law, would it, on this theory?
well, it would actually turn on what are the current private and international law rules. In this court, it's the Insolvency Regulation.
Yes.
Article 25 is mandatory. So when you say take into account, my lord, the answer is yes. And how do you take into account? You must give effect.
And you say that follows from the Insolvency Regulation, but at this time there's no Insolvency Regulation.
Exactly.
So it's a matter of what Luxembourg domestic law says about the application of
Or French law.
French law applying their private international law rules. So at what stage do you say that comes in?
At that stage, the executing court, the Luxembourg court, is they were trying to attach his income. He'd moved to Luxembourg under his free movement rights, and the bank in France was pursuing him and was seeking an income attachment order.
So you say, had Luxembourg recognised applying their rules, recognised the French procedure, it would still have been appropriate to declare the original judgment enforceable, but at the execution stage,
Exactly.
Luxembourg would have been entitled or
Yes.
bound to give effect to the French plan.
Yes. That's what I say. And that's why I say this case is pregnant with the answer to this case, because the law has moved on. The time capture of these proceedings, the Insolvency Regulation still applies. It is our choice of law and jurisdiction rules for insolvency. The jurisdiction is the composition of the main proceeding in Germany. Its law applies to the composition and is given automatic effect without formality throughout the European Union. So if a charging order is applied for, we've just applied for a stay of execution preemptively here. We're seeking a stay of the execution, and we're doing so on the basis of Article 25.
Can I just pursue that a minute? 32. As regards a judgment such as the insolvency judgment, it's for the court of the state in which enforcement is sought in appeal proceedings under Article 36 to determine the legal effects.
It's an interesting observation because it chimes with what I say Advocate Cocott is contemplating. Because when we get to prison and you look back to this, you wonder if the court was saying the same thing. It didn't address it explicitly, but I think the reason my laws come back to it is because is the court thinking, were the insolvency regulation in place or had it been incorporated into the judgments regulation, would that have been a defence at the enforcement stage?
I mean, if it's coming in appeal proceedings brought under Article 36,
exactly,
which we haven't actually checked the identity of, but assuming it corresponds to the judgments regulation provisions, on the face of it, you're bringing in the insolvency judgment at the enforceability stage rather than merely the execution stage.
Exactly, which is what I'm hoping to do on ground
Yes.
3. On ground 1, I'm not seeking to advance the jurisprudence at all. I'm just seeking to apply, in this court, the distinction between registration and execution, and as the executing court, to abide by the requirements of the insolvency regulation, the German plan. I noted, and I hope you noted in my lords, paragraphs 29 and 33, the words solely to the enforceability in formal terms. I just wanted to draw attention to those words because they're obviously words that are harmful to me on ground 3, but I'll be dealing with those when I give a further explanation on ground 3. If I can then move on to the Orams case, my lords. This is tab 6. You'll be relieved to know we don't have to go through the whole of this case. It's a landmark and an interesting case concerning an unfortunate English couple who bought land in the Turkish Republic of Northern Cyprus. They were then sued by the dispossessed Cypriot owners in the Republic of Cyprus, and enforcement was sought against them in the United Kingdom. A lot of points were taken in this case, the first of which concerned the suspension of the European Accords with respect to the territory of Northern Cyprus, others of which included enforcement with respect to land, and there was also a point on service. I don't think we need to turn up any of those points. I can give you the references if they would be useful, my lords, but all that's relevant, I think, is the point on enforceability, which came about in connection with public policy at the same time, because the argument was that you will never be able to enforce this judgment in Northern Cyprus because that's the situs of the land, and the courts of the situs of the land will ignore any Cypriot judgment because of the political situation between Northern Cyprus and the Republic of Cyprus. And so in one sense the case is a very vivid illustration of the difference between formal enforceability and the practicality of execution, because there was no point, no prospect of execution here, and yet the court held that did not matter because the concept of enforcement was a purely formal concept. In this respect, can we first look at the Advocate General's opinion at page 112. I was going to give you a very long reference, my lord. I'll give you the reference so you have it. It's paragraphs 90 to 112 of the Advocate General's opinion, of which the most succinct statement is paragraphs 96 to 99. In particular, paragraph 98. Now, the Advocate General goes on at page 113, paragraphs 104 onwards, to deal briefly with public policy and takes a view that he doesn't need to deal with it. The court takes a slightly different approach, and of this report, it's on page 100, not of the report, of the bundle, page 126. The relevant part of the judgment is paragraphs 53 to 71. Again, that's the complete reference as to where this issue is dealt with in the judgment. The main part for present purposes is the ratio which I've already told you, but also paragraph 55, which I highlighted earlier. It's important to read that paragraph in full, and also paragraph 54 that precedes it, because it's actually dealing with a question of public policy.
Hang on, I'm not with you. What page are you on?
Page 127 of the bundle, my lord.
Thank you. Okay, thank you.
Now, as to the dispositive part of the court's reasoning, that's in tandem with the Advocate General, and it's paragraphs 66 and 69 are the important paragraphs, which set the distinction between registration and execution. And they say that it's formal enforceability that's sufficient for registration, irrespective of the factual improbability of enforcement by execution.
So that's especially paragraph 69, really, is it?
Yes, and paragraph 70 is a more colloquial expression of it. If I can move on then to the PRISM decision, tab 7. It's a decision we've probably talked about a lot already. My lords are familiar with the essential facts. This was a case in which the judgment to be enforced had been settled by a financial settlement, and the receiver, who was then in charge of the debtor's affairs, sought to rely on the settlement to resist enforcement. The settlement was a private law settlement, not a judicial composition in insolvency proceedings, and had nothing to do with the Insolvency Regulation. The judgment was held to be enforceable because enforceability was said to be a formal quality as distinct from its execution or satisfaction, whether by payment or settlement. The cases relied on against me, as I've shown you. I actually rely on the case, certainly on ground 1, because of the clarity of the distinction between formal enforceability and payment. The essential part of the judge's reasoning and that of the Advocate General is that the lack of verifiability of the settlement meant that as a matter of policy it should not be accepted. If we can look first at the judgment of the Court of Justice, the Advocate General's is in the next tab, we'll turn to it in a moment. It's paragraph 26 phrases the question before the court, and this is on page 167 of the bundle. And it was the UK government that was arguing for a defence here, because its main point is, well, what if you paid twice? Or rather, what if you might be forced to pay twice? Then paragraphs 27 to 35, you've got an exposition of the law I would rely on, save for paragraph 33, which I say is an erroneous citation of what Oram said.
Does it matter if the court is clear about what it's saying, even if the source of what it's saying is misstated?
I can see that point, and the answer to it is that there was no issue in this case that required the court to say in a binding way that it's exhausted. So I'm not seeking to play games here. There's simply no issue here that required it to say in definitive terms that Articles 34 and 35 were exhausted. The argument here is necessarily about Article 38. There's a debate about Article 38 enforceability, and thus that very debate concedes that Articles 34 and 35 can't be exhausted. So I see what they say, but I don't think they meant what they said, and Oram certainly didn't support that.
But they don't suggest it does. They're saying two different things. The first is the items of the list must be interpreted restrictively. For that they cite Orams, and that is indeed what Oram says.
Yes.
Then they add, it's exhausted. That's not attributed to Orams, that's their own statement.
My Lord, and that's why I said in answer to my Lord Justice Newey that one has to read the case on its facts. This was a case about enforceability, which is a debate about Article 38. And so if Article 33 were entirely exhaustive, or rather, if Article 3 in its pronouncement that Articles 34 and 35 were exhaustive, that would be the end of the judgment. And they go on to discuss other reasons as to why payment and settlement cannot be considered relevant to enforceability, which is the question that arises under Article 38.
That seems to be a different point with respect, because what I'm on at the moment is your submission that paragraph 33 of PRISM is not supported by paragraph 55 of Orams. And what I've put to you is that it is supported by Orams at 55 because they rely upon Orams at 55 as in support of the proposition that you interpret the list restrictively. What they add in this judgment is something which I entirely agree with you is not to be found in Orams, namely that it's exhaustive, but they don't purport to say that it is to be found in Orams.
My Lord, I accept that reading. I do accept that.
Okay.
But my answer, and I apologise if I confused you, is that the question of exhaustivity was not at issue in this case. It's certainly part of the reasoning. They're saying that the exhaustive defences show a policy reason why you should be restrictive in your interpretation. That's why one of the reasons why they reject payment and settlement outside the terms of a judicial composition as something that can be raised at the registration. It would slow things up. Paragraphs 36 to 42, I would suggest, are an important passage for the present case. I invite you to read this, my lords.
I'm not sure I understand the last sentence of 39. Do you? Well, in fact, I'm rather sure I don't understand the last sentence of 39.
The reference, I think, to the specific characteristics of the judgment in question are those of its formal procedural enforceability, such that it is final binding of a liquidated amount. And that is different from elements of fact and law, such as payment of the underlying obligation or its settlement. In other words, the judgment can remain as a perfect judicial thing that is final, binding and definitive. That's the quality that the judgment has and will always have. But if you pay the judgment debt, then the claim is satisfied. And the UK's submission here was that we are concerned that if you don't give an expansive reading to enforceability, there's a risk of injustice to the debtor because of double payment. And to which the court's answer is, we see that risk, but they say at paragraphs 40 and 42 that you deal with that risk at the national level, at the execution court, by the debtor turning up and proving his receipts and so on. What you don't do is have a protracted debate at the registration stage, which operates, and I appreciate the language is oblique.
So if we go back to my rather simple dichotomy between enforceability and execution, line 2 of paragraph 40 could, in my language, have used execution instead of enforcement on those 2 occasions.
Yes, and I think there's also an echo in paragraph 37.
I'm sorry, I'm a bit baffled. How is your reading of this judgment consistent with the dispositif? The dispositif seems to say the opposite.
The dispositif does suggest that it's a case under Articles 34 and 35. And then at the end, it precludes the court with which an appeal is lodged under Articles 43 or 44, so that's in our case, it's the English courts, from refusing or revoking a declaration of enforceability on a ground other than those set out in Articles 34 and 35, such as compliance with that judgment in the member state of origin. So isn't it saying in terms you cannot invoke compliance with the judgment, e.g. payment, as a reason for refusing a declaration, unless you've got grounds that are set out in Articles 34 and 35. My Lord, I see that is the reading of the dispositif. I do see that, and that's the short answer, whether it's expressed it. What I was suggesting is that if that were the only thing at issue here, the judgment would actually stop at paragraph 33. You wouldn't need to go further. And they are going further to give reasons as to why the act of payment or an ad hoc contractual settlement. And as we'll see, the court says nothing about the question the Advocate General expressly left open. So even if one takes the reading that my Lord has just put, in terms of my ground 3, I would suggest that the debate is legitimately left open. If my Lord doesn't agree with me that once I've shown you the material, then I would not succeed on ground 3 and probably not ground 2 either.
So at any rate, where you're concerned with the question of payment, which is not a judicial act, that can't be brought in at the enforcement stage in the technical sense. It has to be aired at the execution stage.
Yes. Yes. And my case, as I've said, is that this is a case not of payment, because the composition is a payment of less than full satisfaction, but by reason of being a composition made binding by German law and given effect to the Insolvency Regulation, it's as good as payment. Subject to the debate my Lord and I had at the start to clarify that it's not discharge here because German law is treating it as an imperfect obligation. But if you were to imagine having paid a judgment debt and then someone gets to charging order over your house or tries and you say, look, here's the receipt, I've transferred the money into your bank account, execution would be stopped. It would be monstrous if someone could say, well, the judgment is still formally enforceable. Look, I've managed to get a copy from the issuing court, pay me again. That's not right, and that's what Prism says it isn't the law. Here, you've got someone who can't afford to pay in full, has done a composition, got a third party to contribute to their assets to pay them more than they would receive in a bankruptcy. And so when times were bad, they did a composition. Now times are good, and Mr. Windhorst is notorious for being wealthy now. And he's being pursued by a judgment debt that is historically, it's 18 years old. And in our submission, PRISM does provide an answer to this case, but I entirely take my Lord Justice Arnold's point that it is a case that is, on one view, against me, on certainly ground 2, probably ground 3 as well. However, it is, I say, with me on ground 1. If I can show you briefly the part of the Advocate General's opinion concerned with time at this point. If I can take you, I'll give you the references to the remainder of the Advocate General's opinion. It's paragraphs 19 to 22 and 47 to 48 are the material parts of the Advocate General's reasoning that do coincide largely with that of the court. Paragraphs 57 and 58 on pages 182 and 183, however, address briefly the further question that was left open. So on page 182, on the bottom right-hand corner, you have a subheading beginning special case of uncontested defence. So this is a special case that's considered as a matter of argument. I invite you to read paragraphs 57 in its entirety. And it's in particular the words, or where it has been determined in a conclusive binding way.
So just bear with me a moment. Yes.
So it's the word says, in situations which the satisfaction of the claim is uncontested by the parties, or, and this is the relevant alternative, or where it has been determined in a conclusive and legally binding way, and where it, the word it must refer back to the start of the sentence and the word satisfaction. And the opinion expresses there's much to be said that that would be a defence. However, since this question was not the subject of proceedings at issue, there is no need to give a final decision on this point. And the case I'm advancing on ground 3 is that we now have that case before the court, and that the policy reasons identified in the reasoning of the Advocate General and the court, I would say, point to the answer in this case on ground 3. I accept I have to get over the gateway question that my Lord Justice Arnold has identified, and that's the perimeter question which we've already discussed and to which I'll return to. Finally, before going to the
paragraph 58, which you also asked us to read, is concerned with which court would be addressing the satisfaction issue, whether it's the executing court or the member state of origin.
Yes, and the Advocate General has picked up Article 22.5 that my Lord had picked up.
Yeah, so the parallel question here would be, is it this court or is it a German court that has to work out whether the composition is binding.
Well, this happens all the time, though. I mean, every time there's a European bankruptcy, the English court often sees it as a defence to act. And I pleaded this. One doesn't have to work it out because the composition is the judgment. You see the plan, you get a translation of it. That's the way it's meant to work. You give effect to it until it's been set aside. So this difficulty of, is the English court as the execution court burdened with the complex question of European law, is no, because that's the opposite of what the schematic is intended to do. The judgment stands, it can't be reviewed as to its substance. That is true of a judgment under the Judgments Regulation, and it's also true of a judgment under the Insolvency Regulation. One isn't an inferior quality of judgment relative to the other.
Yep.
I'm sorry if I'm being really slow about that. But so the only distinction in this case is that you've got the argument about whether the subsequent payments have unravelled.
That's right. There's a dispute from the other side of the court.
So far as we're concerned, I mean, in a way it shifts the entire burden onto that, which we're not in a position to determine.
Exactly. And that is my point, that when I took you to my learned friend submissions earlier, that they've raised a dispute. They very fairly said it's no more than a dispute. But you can always dispute.
But you said you've got two set pieces, namely the 2003 judgment and the composition.
Exactly.
And that's it.
Yes. And that's the final part of these submissions, which I'll take you through.
I'm sorry to be so slow, but
that is my submissions, my lord. Can I just briefly have a word on Salzgitter before moving to the German for evidence, my lord? Salzgitter concerns conflicting judgments under the Judgments Regulation. The Court of Justice of the European Communities held that the conflict did not permit the court sees of execution to refuse registration because there were conflicting, in that case I think, Romanian judgments. Now Article 34D deals with conflicting judgments of another member state and the state from which the judgment in question emanates. It doesn't deal on its terms with two conflicting judgments from the same member state. And so the argument in Salzgitter is, can one crowbar into Article 34D that reading? And the court said no. Because if one did, well, it's not within the wording it says, but also it would go against the scheme of mutual trust. This case is irrelevant for present purposes because the Insolvency Regulation and the Judgments Regulation are exclusive. The court, I think, will be familiar with the Gordon and Nadler line of authorities going back to the 1970s that say the judgments in insolvency are conceptually exclusively distinct from civil and commercial matters. The Insolvency Plan doesn't conflict with the substance of the judgment. That's a judgment in an unjust enrichment action in relation to a failed investment and the misuse of monies in 1999. The composition doesn't say anything at all about that. What it does is it takes the claim in respect to the judgment and compromises it. The relevant parts of the judgment, I don't think I need to turn it up. It repeats the same line of authority as Fortis and Prism. Can I then move on to the evidence of German law? Put the authorities bundle away and take up the supplemental. Can I start with the witness statements? We've got the witness statement of Mr. Joachim Lenhardt, who's a German lawyer for Mr. Windhorst. This is at tab 1 of the supplemental bundle. I'd invite you to read paragraphs 5 to 11 on pages 2 to 4. And so you have it in mind when you're reading it, these paragraphs are expressly agreed to in Mr. Levy's evidence. I emphasise in particular the last sentence of paragraph 11. So that is common ground between the parties. Subject to this dispute about voluntary payments, this composition has not ceased to have effect. I can then leave Mr. Lenhart's statement, and if we take up Ms. Coolman's statement at tab 3, page 214, pertinent part begins on page 215. I'll ask you to read first paragraphs 4 and 5. And then can I invite you to read paragraph 6 through to 11? Actually, through to 12, please. In particular, my lord, paragraph 11, second sentence, the evidence is that the Senate, so the Senate of the Bundesgerichtshof, added that it is not for the enforcement court, being the German enforcement court, the sees of the issues under the ZPO, to decide whether the claim to be enforced is the subject of a residual debt discharge. That is, the in that case, the English bankruptcy. They go and say that's for the trial court. That's what paragraph 12 then says. And I'll take you to the decision in a moment, but I rely on this evidence and the German decision, which I'll take you to, because there is a distinction in German law between formal enforceability and substantive rights. The enforcement court is concerned with matters of German procedure, and it is what they call the trial court that deals with matters of substantive rights. In this case, the English bankruptcy discharge, which discharges the bankruptcy debt. And what you're told at paragraph 11, and this is important when you read the decisions of the Court of Appeal of Ham and the lower court below, it's that it's not for that court, being an enforcement court, to decide anything about the residual debt discharge. So there's no decision in the proceedings in this case from the German courts as to the effect of the German Insolvency Plan, either negating it or in any way. It's not a court that can pronounce upon it, and that's the evidence of Mr. Levy's lawyer. He says the same again, or rather, Ms. Coulmer says the same again in paragraph 13. There is no decision that can emanate from the German procedural courts with respect to the residual debt discharge. And I've shown you the evidence that shows it's common ground that hasn't ceased to have effect. What Ms. Coulmer goes on to then articulate at paragraph 14 is the dispute in respect of the voluntary payments. And it's very fairly accepted that that's a dispute and nothing more. My lords, using the time I have left, can I ask you to turn up the Bundesgerichtshof judgment, which is at tab 2 of the same bundle. It's on page 87. I'll have to do this briefly, my lords. The issue in this case was whether the German judgment debtor could resist enforcement of the judgment by placing a notice against enforcement based on the English bankruptcy. The translation uses the word reminder as a slightly awkward translation of notice, but the Bundesgerichtshof held that it's not the appropriate procedure under the German ZPO to just stick up a notice against enforcement. If you want to dispute a German judgment and have it set aside, the way you do that is you apply under 767 to the trial court, pleading the discharge as a defence, sort of post-judgment defence. And the reason it says that is that essentially it says that's the majority view when one reads the commentators, because that's what the German court has done, is it's taken views of the commentators. It says that's the majority view, but also it says as a matter of policy, it says it's going to be very difficult for a bailiff or an enforcement officer to understand the effect of a residual debt discharge, i.e. the discharge under a bankruptcy, especially a foreign bankruptcy. So it says that is better dealt with by the trial court. That's the ratio of this decision, and that bears out the paragraphs I've shown you. The ratio is in the head note. It deals with an English bankruptcy and its effect in Germany. The ratio is repeated over the page at paragraph 8b. Paragraph 9a, 9AA, is essentially the submissions. And what they say at 9AA, in the literature is sometimes argued the enforceability of titles is directly eliminated by the discharge. So the enforceability of titles, the order, that's the minority review, that the debt discharge knocks out the order itself. That's the minority review. Dropping a few lines in a different view, so another minority view, is that basically you should do this because it makes life easy for consumer debtors who probably don't have a lot of money to go to the trial court and can stick up a notice against enforcement. So that's another minority view. But it said that the vast majority of respondents take the view that a judicial declaration is required to remove the enforceability of an order issued before the granting of the residual debt discharge. So the logic is that because an order is a creature of judgment, one needs another judge to make a decision to wipe away the quality of that judgment as one that's enforceable under the procedural code. That's the essence of the reasoning, and the Senate prefers that over the page at 10BB. So it agrees with the majority opinion. And it says, the debt discharge is not an enforceable decision from which it follows that the judgment to be enforced has been set aside or that the enforcement declared inadmissible. And so it's explaining that a debt discharge which targets the underlying obligation is not something that has the effect of impeaching the procedural quality of the judgment. It then goes on to consider, and you've seen it in the evidence, that you can't have an analogous application of 775. That's the next part of the reasoning. And then it adds, it's pretty difficult for the enforcement body or bailiff to look at a notice, so you can't do it that way. It's not for the enforcement court to decide whether the claim to be enforced is subject of a residual debt discharge. And then it goes on in its final paragraph to explain that the residual debt discharge, I do apologise for the highlighting on this report, creates an imperfect liability. And then it concludes, this reorganisation of the claim, as distinct from the judgment, gives rise to a substantive objection under substantive law, which can only be pursued with a counterclaim for enforcement. In the event of a dispute, it is not for the enforcement court, dealing with procedural rights, but the trial court, dealing with the substantive obligations, to assess the effect. And so, not quite a mirror image of the distinction we have at European law between registration and execution. We have a distinction between procedural enforcement and substantive obligation. The discharge in bankruptcy, in this case a UK bankruptcy, is a discharge of the right. And my lords, that brings me almost to the end of my submissions.
How much longer will you need?
Very little, because I've got this fourth heading of developing our submissions. We have essentially discussed all the developments we wish. If I might have, with your indulgence, some time over lunch to consider, because I owe you some answers to some questions, and maybe 10 minutes if I'm conscious of the time.
I mean, all being well, submissions and answers should take a bit less time because the person making the submissions and answer doesn't have to go through all the materials.
I didn't want to say that myself, Mike. I've taken most of the burden of exposition.
I'm going to say Miss Vannegut, but you tell me, how do you actually pronounce your name, please?
It's Vannegut. So you just
Vannegut.
pretend the first letter's a V.
Good. How long do you think you will need?
Probably a bit over an hour, my lord.
So if Mr. Arlata has 15 minutes after lunch, that should be fine.
That's perfectly fine, yes.
Well, in that case, let's stop now and we'll start again at 2 o'clock.